Nick de Young was admitted to practice 12 years ago in April 2000 and came to the bar in May 2007. So he's practiced at the bar for 5 years. He's mainly, as with Elizabeth, he's mainly concentrated in the field of commercial litigation, so ideally suited to this sort of topic, with a specialisation in corporation securities and trade practices law. Now, in that area, he's appeared in the federal court in ASIC, in one of the ASIC cases against Healy with the great Alan Archibald, QC, and I don't use that term lightly in respect of Alan, and with Philip Crutchfield SC in Centro Properties case, in several Supreme Court commercial litigations at high level, and also in VCAT, which is dealing, unfortunately in my view, but dealing more and more with leading commercial cases. As I said earlier, Nick also had a role in one of the Fortescue metal cases. It was an access dispute under Part 3A of the TPA, whatever that is, and he might explain it to us. But he's ideally suited to present his paper on the more technical aspects of the Civil Procedure Act, and I'll hand the floor over, or hand the rostrum over to Nick in that context.
Thanks, Tony, and good morning to everyone. The focus of my paper today is going to be on the implications, and I pause there to add, if any, of the overarching obligations on lawyers' obligations in actually drawing or drafting a pleading. Now, the process of sitting down and drawing a pleading is obviously inexorably linked to the process of ensuring that there's a proper basis for the allegations that are made therein, and that's the topic that Liz has just talked to you about, in the sense that you'll perform both these tasks at the same time. You'll be sitting and thinking, well, what do I need to have in my pleading, and do I have a proper basis for it? But for present purposes today, the legal principles can be dealt with separately. And picking up where Tony started first thing this morning, whilst a recent decision of a federal court judge has lent some support for the proposition that the new Civil Procedure Act and the overarching obligations has changed the obligations of lawyers with respect to drafting a pleading, I think that the better view is the one that Tony and Liz have already expressed to you, that really there's been no change in the obligations, and what the Act has done is just put focus on them, or to use the words of Justice Perham in a recent case in the federal court, added impetus to those obligations. And I'll take you to a couple of those decisions in a moment. They're also dealt with in the paper that I hope you all have in front of you. What I want to do in the presentation this morning was firstly to just identify the relevant provisions in the Civil Procedure Act that pertain to pleadings, and in particular drawing pleadings, and to examine, secondly, to examine the current duties of lawyers with respect to drawing pleadings, and also consider whether there's been any change, and finally consider some of the ramifications of failure to comply with those obligations, and as Liz said, it mostly sounds in wasted costs orders against solicitors. I'll, like Liz, follow the structure of my paper. In paragraphs 1 and 2, I've set out what the obligations or the relevant obligations in the Civil Procedure Act are. Just in paragraph 2, I've set out that there is this paramount or overarching duty that is imposed in the Supreme Court and County Court and Magistrates Court directly on lawyers. And so the lawyers in those courts have this direct obligation to comply with the overarching obligations, and that can be contrasted to the position in the federal court, for example, where the lawyer's obligation is to assist the client in complying with the the overarching purpose in that court. Whether there's any difference between the two at the end of the day, I'm not sure, but I do understand there is some proposed federal reform, and it may be one of the things that that's picked up there. In the Civil Procedure Act in Victoria, there are, in addition to the paramount duty, which is to further the administration of justice, there are contained in the Act a number of specific duties. Now, there's no specific duty targeted directly to pleadings, but there are at least two duties which, in my view, could be said to be relevant, and they are, and this is set at the very bottom of paragraph 2 of the paper, to use your reasonable endeavours to narrow the issues in dispute and to minimise delay. And I'll come back to how it might be said that they are relevant to lawyers' obligations in drawing pleadings. Now, as Tony's indicated, that lawyers have always had obligations in drawing pleadings, and those obligations have really come from two sources. The first is as officers of the court, and the second is in respect to their duties to the client. The first, and this is the historical position, if you'd like, the first of those, which is their duties as officers to the court, is dealt with in paragraph 4 of my paper. And these are essentially sound in the wasted cost cases, Flower and Hart being the most famous of which was the decision of His Honour Justice Goldberg. And the duty, the relevant duty insofar as pleadings is concerned, is really been pleadings that have sought to agitate a hopeless case. And that was the position in Flower and Hart. There's also obligations on lawyers not just to pursue a hopeless case, and I'll come to what it means to have a hopeless case in a moment, but also not to act within propriety as a lawyer and officer of the court, and that means not putting forward allegations in a pleading that the lawyer knows to be false. And there's been a recent decision which covers both those topics, which I've referred to in paragraph 4 of my paper. It's Apollo 169 Management Proprietary Limited and Pinefield Nominees. And that was a case concerning a property development in the very picturesque Apollo Bay, where the lender brought an application for possession of the property for non-payment of the mortgage, and the borrower defended the claim in the Supreme Court on the basis of alleged oral representations that had been made by the lender, sounding in an estoppel and misleading or deceptive conduct. Quite a common scenario, trying to resist the application for possession of the property, no doubt because the borrower in that case wanted to finish the development. The proceeding was commenced and the plaintiff made an application for summary judgment immediately. This is pre-Civil Procedure Act, so it was the old test for summary judgment. The summary judgment application was resisted by the defendant, and the defendant's officer filed an affidavit which deposed to these relevant conversations in which the alleged misrepresentations were said to have been made. The matter proceeded to trial, and over the weekend before the trial, counsel conferred with this director in the presence of the solicitor, in which conference the director conceded to the barrister and the solicitor that affidavit was effectively false and that those conversations had never occurred. What then transpired was a discussion about a potential alternative defences to the claim, one of which was more of a conventional estoppel, but based on other facts which aren't relevant. The trial started on the Monday, and the barrister opened the case not referring to the oral representations which had been pled, but referring to conventional estoppel. There were other claims made in the proceeding which we don't need to worry about, but the relevant claims with the mortgagee. Now, the case went for 5 days against a number of parties, and at the end of the trial, no evidence had been adduced in relation to the oral representations, and they hadn't been opened about. And the conventional estoppel case that might have existed had completely evaporated, and there was essentially no defence. The court, of its own motion, moved to make a wasted costs order for the trial against the barrister and the solicitor, and then the aggrieved other party, the lender, joined in that application. And the court ultimately made a wasted costs order, in that case under Rule 63.23 of the Supreme Court rules, which is the sort of flower and heart style rule, against both the barrister and the solicitor. And importantly for present purposes, one of the bases that the court made the order, perhaps it might be the principal basis, was that the pleadings were false. And even though the barrister hadn't opened the case by reference to the pleadings hadn't been amended. And the court made the wasted costs order, as I said, in part because the pleading was still there on the record and hadn't been amended and was false. That's the historical position, and as Tony's indicated, even under the new Civil Procedure Act, that would sound in the same way. The second area of traditional obligations for lawyers in drafting pleadings has been to the client, and I've dealt with that in paragraph 5 of the paper. Referred to a New Zealand case of Watt and Cohen and Wills, where a solicitor drew a pleading on the wrong contract and summary judgment was entered. The solicitor was held to be negligent in that respect. There'll obviously be overlap here with the advocate's immunity, and in particular for counsel, but also for solicitors, where the work done in drawing the pleading is intimately connected with the presentation of the case in court. Then the advocate's immunity will kick in. And there's a case that I've not referred to in the paper, but it's Keefe and Marks, 1989, 16 New South Wales Law Reports 713, where a claim against a barrister for failing to plead an entitlement to interest was not allowed to proceed on the basis that it was covered by the advocate's immunity. So there'll be overlap there. That's the traditional position. Now, the new Civil Procedure Act, the relevant question is, has it made any difference? Is there any different or higher obligation for lawyers, both solicitors and barristers? As I indicated in my opening, His Honour Justice Gray of the Federal Court has handed down a recent decision where His Honour expresses the view that there has been a significant change in the duties of lawyers in that court. Now they've had the overarching purpose obligations and requirements in that court for longer than the Supreme Court, and there are some differences, as I highlighted before. But it's likely to be the case that the Victorian provisions are considered to be more onerous than the Federal Court provisions, so anything His Honour Justice Gray said in that case, at least theoretically, has application to the Victorian courts. The case in which His Honour Justice Gray made those remarks was Modra in the state of Victoria, and it's worthwhile I've set out a summary of the relevant facts in paragraph 7 of my paper, but it's worthwhile considering the facts of that case in a little bit more detail, because it does provide some practical guidance for lawyers and barristers in drawing pleadings, particularly under the new Act. Now, that proceeding was commenced in the Federal Court by an application, so no statement of claim was filed. There was a first directions hearing, and as Liz has indicated earlier, the first directions hearing in the Federal Court is often a very exploratory process, and there was discussion about what was necessary to be included in the pleading, and the solicitor appeared without counsel on that occasion. The court made an order that there be a statement of claim filed, and made a slightly unusual order specifying what should be in the statement of claim. The order the court made was really probably no more than a restatement of the rules of pleading in any event. After that first directions hearing, a statement of claim is filed, which His Honour Justice Gray took the view, quite properly I think, didn't comply with his orders. There were still some deficiencies in the pleading. There was a second directions hearing before His Honour Justice Gray, and he again made an order that there be amended statement of claim filed, and made an unusual order specifying what he thought should be in that claim. On that occasion, the junior counsel appeared on behalf of the plaintiff. At that directions hearing, the court also suggested that perhaps senior counsel with experience in the area should be briefed. That duly happened, and an amended statement of claim was filed and served, which had been settled by a junior counsel and senior counsel. Now, following the filing of that amended statement of claim, the defendant's lawyers, who was the state, sent a letter to the plaintiff's solicitors making various complaints about the pleading, both substantive and form objections. And the solicitor for the plaintiff responded to that letter in quite brief terms by merely suggesting that there be an adjournment of the directions hearing that was scheduled to take place in a couple of days to enable the parties to further discuss this. Came back before Justice Gray, and Justice Gray himself thought that the pleading was deficient in two areas relevantly different from the areas that the defendant's solicitors had identified. And the two areas that His Honour Justice Gray felt it was deficient was, firstly, that there had been a number of matters pleaded as particulars that His Honour Justice Gray took the view that there ought to be material facts, although there was debate about that between senior counsel and His Honour Justice Gray. And the second area was that the order that the court had previously made provided that all relevant particulars needed to be provided, and in respect of loss and damage, there had been a half a page of particulars of loss and damage. It was a case about disability, so it was personal injury and so forth, and contained the very common phrase at the bottom that further particulars would be provided prior to trial. His Honour Justice Gray took the view that wasn't all necessary particulars, and therefore the pleading didn't comply with his orders. The court, of its own motion, moved to make a wasted cost order, effectively, against the solicitor for the defendant's costs thrown away, personally. And he ultimately proceeded to make that order against the solicitor, even in circumstances where senior counsel who had appeared for the plaintiff had informed the court that he took full responsibility for any deficiencies in the pleading. Now, there were some unusual features about that case, which I'll come to in a moment, but just on the test to be applied, and this is dealt with in paragraph 7 of my paper. As I indicated earlier, His Honour Justice Gray said that there was a significant change that had been affected by the overarching obligations. And he made that observation not directly targeted to pleadings. He didn't say, well, look, it's changed lawyers' duties with respect to pleadings per se, but the statement was made in that context. The matter went on appeal to the full court, or leave to appeal, I should say, and leave to appeal wasn't granted, and the Judge of Appeal didn't deal with the question of the appropriate test to be applied. But on one view, at least, what His Honour Justice Gray was saying, that he thinks that the Civil Procedure Act type obligations have raised the bar for lawyers. A critical issue in that case, and this is picked up at paragraph 8 of my paper, is reliance on counsel in this area. And it's always been the case and continues to be the case that solicitors can place reasonable reliance on counsel. The question that arises is what is reasonable, and what is reasonable reliance will depend obviously on the facts of each case principally, but potentially needs to be considered in light of the new Civil Procedure Act obligations. And this is picked up in detail in paragraphs 9 and 10 of the pleading. And one of the particularly paragraph 10 of the paper, one of the key factors for the court in this decision of Modra was that the deficiencies in the pleading were obvious in the view of the court, and that I think highlights the need for solicitors, even where counsel is briefed, to carefully review and discuss with counsel any deficiencies in the pleading. And His Honour Justice Gray was certainly of the view that, and this is correct, that solicitors cannot avoid their obligations in relation to pleadings by merely briefing counsel. One of the other criticisms that His Honour Justice Gray made of the solicitor in that case was that he didn't adequately respond to the letter which had come from the defendant's solicitor indicating deficiencies. And I think His Honour Justice Gray took the view that the solicitor hadn't properly turned his mind to that letter and dealt with it adequately, and that again highlights the need for practitioners to carefully consider any such correspondence, and if counsel is briefed, bring that to his or her attention. In a sense, I think what His Honour Justice Gray was trying to do was to set up really a negligence type test in this area, where essentially what he was saying was that it was negligent for the solicitor not to have detected or picked up that there were errors or deficiencies in the pleading. Similar to Justice Middleton's decision in the Centro case, a decision quite close to my own heart, where he said the directors of Centro were negligent in, even though they had PwC briefed and retained to audit the accounts of Centro, they were negligent in failing to read it themselves and detect that there were deficiencies in it. So, where does that leave us in considering whether there's been any change to the responsibilities of lawyers with respect to pleadings? I think the better view is there probably has not, as I indicated earlier, but just that this Civil Procedure Act has provided impetus and something for the court to latch onto, as Liz said, in the event that pleadings are deficient. In paragraph 11, I've set out some potential other areas where the Civil Procedure Act overarching obligations may bite, and they're the ones I referred to earlier, which are the obligations to narrow the issues in dispute and to minimise delay. I think that ought to focus lawyers' minds on pleading the real issues in dispute and not pleading peripheral allegations, and it fairly and squarely, I think, raises the question of whether there's been any change for defences which raise bare denials. And in my own practice, I've observed that defences which assert bare denials are more and more commonly being met with immediate applications for summary judgment under the new provisions of the Civil Procedure Act. And as I think we're probably all aware, they set a lower bar for applicants for summary judgment. The test is easier to satisfy, and that has potential for ramifications on solicitors who just file defences with bare denials. And as Liz said, it overlaps with the proper basis certificate. Do you have a proper basis for saying there's a defence here? And that's something that needs to be considered. Finally, I just wanted to discuss some potential consequences of lawyers failing to meet their obligations under the Civil Procedure Act. The principal ramification is costs, or wasted cost orders as they used to be called. But the new Act does provide for the court to order that the legal practitioner compensate any party for financial loss which has been what's described in the Act as materially contributed to by the contravention. It sounds a lot like damages. Now, there's been, to my knowledge, no authority on the overlap between that potential order and the advocate's immunity, and there must be scope to argue that the advocate's immunity ought to prevent really damages claims being made under the guise of this new act. And that, so far as I understand, is a new entitlement or new power that the court has. The court's always had the power to make the costs orders, but not the compensation. In this area of lawyers' liability for pleadings, two practical things commonly arise which I wanted to note. The first is the impact of legal professional privilege, where sometimes, in fact, in my experience, a lot of the occasions where lawyers are subject to applications for wasted cost orders, it's the court's own motion. And sometimes it's the other parties, but it's commonly the court's own motion, and the lawyer can often commonly not defend himself properly or herself properly because he's unable to reveal the discussions he had with the client because the client refuses to waive legal professional privilege. Now, the English cases have set out a test, and they've been picked up in Australia, that allow the court to respond to that by drawing all inferences in favour of the solicitor or barrister because he can't adequately defend himself. It's theoretically there, but it does present a practical dilemma for solicitors in trying to defend these applications. The second thing is the availability of insurance. I'm not going to advise you on what the policy is and says, but it's there and you should know about it. And notifications to the insurer should be made promptly.
Thank you, Nicholas. I feel fully vindicated in my opening high praise of both Elizabeth and Nick. They've fully justified, in my view, that praise. They've both delivered extremely perceptive and concise papers on the pleadings issue generally and the CPD specifically. That has brought about two particular views in my mind. I'm starting to revise the opening views I expressed as to the relevance of the CPD to pleadings as opposed to the pre-CPD scheme, and it's also caused me to review in my mind as I was sitting there during the papers as to recent pleadings that I've drawn, and I may well be going back to my juniors on the telephone as soon as this session is finished and expressing my righteous anger that I haven't been fully informed as the implication of the CPD. But seriously, I do think it's been more a matter of form and a matter of highlighting the deficiencies of pleadings. Courts have always had the powers to award costs, including solicitor-client costs / indemnity costs, whatever you like to call them, in the event of pleadings being inadequate. The concept of truth in pleading has been around since I remember running a case in front of Mr Justice Byrne almost 30 years ago when he wrote the whole decision on the basis of the concept of truth in pleadings. I was actually turning up to strike out a statement of claim on totally different grounds, and he honed in on this concept of truth in pleading, which is in essence what the CPD legislation is all about. But it certainly does, as Mr Justice Gray said in that case, highlight the issue in more clear focus, particularly with the sanction of costs against solicitors and barristers. I now open the floor to questions, but I do have one question that came to my mind when Nicholas was presenting his paper, and that arose from the Apollo 169 management case. As I understand it, I haven't read the judgment, the summons for final judgment and leave to defend was obtained on the basis of an affidavit which was basically a tissue of lies, unbeknown to counsel and solicitors, who subsequently identified that in conference. Is that correct?
That's entirely right. And
then counsel ran the case before the court and it was lost. He ran it on a totally different basis. This is an interesting question. What if he, being a clever barrister, had identified an unbeatable point and had won the case on the revised allegations at trial, what is the consequences for the summons for final judgment, which is obtained on a totally hollow, untrue basis? It couldn't obviously, I would suggest, couldn't affect the outcome of the decision. It's a hypothetical case, but it could happen. Presumably, though, it would visit an order for costs upon the plaintiff in relation to the SFJ and everything that occurred between then and the date of trial. What would you say about that?
It may well do. I should have also added that in that case, the solicitor was held liable for the costs as well as the barrister.
Yeah.
And some of the arguments which were ventilated at the hearing but weren't picked up in the judgment were more targeted towards the solicitor because it was he, in that case, who obviously took the early instructions from the client. It was he that drew the affidavit in opposition to the application of the summary judgment, and the barrister was briefed quite late. And so
we always are.
There was certainly unresolved issues about how and why that all occurred and what fell from it. The reasons they weren't ventilated or resolved before the court was that the application was only in respect of the trial costs.
I see, yeah.
And that was the only application that was brought against the solicitor and the barrister, and the early costs, but for reasons which I don't know, weren't perhaps they'd been paid. That might have been the case.
Yeah.
I don't know.
You may not know. Yeah. Okay. Well, that's my question. We've got at least a quarter of an hour for questions from the floor. If you'd address your questions through me, and Nick or Elizabeth, as the case may be, or both, can answer. Bruno Alderuccio.
Yeah. The first question is
well-known litigant.
As a solicitor, the obligations when you first pick up the matter. Obviously, we've got a job to do. How intensive should the inquiries be pre-issuing as compared to a defence is filed by the other side, and there may be issues related to your pleadings that arise there, and then also later on correspondence and discovery and material arises that questions your pleadings. What's your view on the level of inquiry initially? Because if you, yes, you can interrogate the client, but if you go to the nth degree right at the start, you're going to lose that client in 5 seconds.
Elizabeth, first.
I think as intensive as time allows. I think there's no point keeping a client for the sake of putting in the claim that will be lost or be, the client needs to understand that they need to be able to support what they're saying, and there's no point hiding that fact from them. There's no point mollycoddling them. They've got to be able to answer some tough questions. You may as well put some difficult questions at the beginning. It's in their interests ultimately. It doesn't need to be. It doesn't need to take an extraordinary amount of time. We all know what the basal elements are going to be. We're not talking about credit points. We're not talking about peripheral issues of interest. We're talking about the key points that will underpin the claim, and I think that they should get as much attention and interrogation as you have time. And if it's urgent and there's an interlocutory injunction and you have to act on instructions, great. And if subsequently, and you only get time for the full-on interrogation, third degree, subsequently, well, you do the best you can in the facts you've got. But I think the most interrogation you can do in the time that you're allowed, and I don't think we should be too concerned about scaring off people. It's scary. They've got to be aware that they've got to be able to substantiate their claims, and the sooner they're aware of that, the better. Do you have a different view?
No, that's entirely right. I mean, it's one of reasonableness.
Yeah, I was about to add, a court will never penalise a solicitor or counsel where they've acted reasonably. They may not have even taken every possible conceivable step that they ought to have taken with the wisdom of hindsight, but if they've acted reasonably at the time, a court will never unfairly visit them with an order for costs or even any undue criticism. That's about the best you can say.
Yeah, the old test, pre-Civil Procedure Act, comes out of the English authorities, Myers and Elman, Harley and McDonald, was gross negligence. Yeah. So serious dereliction of duty was required before an order for costs was visited upon a legal practitioner. and unclear from Gray's decision whether he was of the view that the new Civil Procedure Act has changed that. I might think probably not, because but in the area of pleadings, but both Justice Gray and the full court, single Justice of Appeal, said that pleadings perform a very important task, and so any or perhaps most derelictions of duties pertaining to pleadings will be considered to be serious. So it is an area that you need to really think about in that context. Further questions? Yes.
Can I make an observation in addition to Elizabeth's excellent summary of the Sunland case? The first is that the Sunland case, in particular the costs judgment, is, in my view, a very necessary read, a cautionary tale on any number of procedural matters as well as the pleading matters. And it'll remain a cautionary tale when eventually the appeal to the substantive proceeding and the appeal to the costs proceeding is heard.
Is it currently under appeal? Yes.
Each of them are. And the second but relevant point, though, is this, and this needs to be highlighted. Central in the Sunland case was an allegation of deceit, which we all understand is always and has always been attended by very, very particular obligations in counsel. And in my view, for the reasons expressed by those presenting the papers, is that those obligations will not be added to by the current legislation. They will always remain the fact, and indeed they are obligations which in part are shared by solicitors instructing counsel. The second thing is that there was in the Sunland case, in addition to the deceit allegations and the trade practices and fair trading allegations, an allegation of common purpose, that is deceitful common purpose to further a representation as to a state of fact which was knowingly false.
That's almost a conspiracy, is it?
Indeed. And there were therefore, which is why it is the judgment, in particular the cost judgment, which summarises the 300 pages of substantive findings, why the cost judgment is a very useful read, because the costs judgment addresses the interlink between the representational claims under the Trade Practices and the Fair Trading Act, the deceit claims as well as the common purpose claims, and it relates them very carefully through the matters to which Elizabeth has in careful detail referred, but not addressed of necessity in detail, questions of reliance and questions of causation. So all of the matters that have been referred to in Elizabeth's paper, as illustrated in the Sunland judgment, are very well made, but it is important to note the significance, indeed the central significance, of the deceit and the common purpose allegations in that case.
Do I take it that you were one of the counsel in the Sunland case?
I've got a passing familiarity with it,
Yeah.
I have to say.
Obviously, thanks. Further questions? Yes.
Do you have a view about what a defendant should do in circumstances where you're under pressure to file a defence and an allegation is, and this arises particularly in, say, a professional negligence claim, particularly in medical negligence, where a client, so the defendant instructs you that, yes, I've acted in accordance with peer professional practice and I have this defence under the Civil Liability Act, yes, or whatever that defence is, whatever act that is, but I've acted in accordance with peer professional opinion. And are you under an obligation to go and get expert evidence before you plead that defence, or do you think you hold, what do? Do you hold fire and amend your defence subsequently? Do you have a view? Because you've got to have a proper basis for any denial or response to a claim.
Nick?
I think there's no easy answer to the question, Kate. Really, you have to use your judgment at the time. Now, often defendants can find themselves in a predicament because, especially in complicated professional negligence cases where the timelines for defences are quite short, and you're trying to gather instructions in relation to a complicated claim about a complicated set of facts and put in a defence within the time that the court's allowed you, which is not that long. My own view is that there's potential issues associated with just having a bare denials defence particularly you'll find yourself filing an application for summary judgment under the no real prospects test, which is a broader test. The only practical advice that I think I can give is to ask for more time.
Yeah.
Now,
A letter seeking more time to file your defence.
Particularly in view of the obligations, one of the overarching obligations is the duty to cooperate amongst practitioners. I think it's really open to say, well, you know, we need more time to take instructions. Now, if that requires the taking of some expert advice, then that's certainly a prudent step. I know my own practice in professional negligence, when acting for plaintiffs, it's really, apart from lawyers' claims, which are the court's their own expert, in many other claims, more often than not, the plaintiff will want a pretty well progressed expert report before commencing in order to satisfy the basis requirements. Take, for example, negligent financial advice or sometimes negligent legal advice as well.
Yeah, I agree with that.
Yeah. Thank you. Does that help?
Thank you.
I think the first thing is a letter to the plaintiff solicitors saying that you need more time. Gives another 14 or 28 days. Bruno.
The Pearl Lingerie case, there were comments by the judge there. One of the caveats was not lodged by the solicitor.
Yeah.
Now, and what I'm looking is your view going forward, because this caveat issue and proper basis, I think it's very strongly interlinked. Sometimes you're asked about lodging a caveat, you've got some doubts on it. The client says, all right, okay, I'll go and lodge it. Give me some wording. Now, if you end up, the caveat's lodged and ends up in court and you're the solicitor in the matter, the comments there by the judge indicate, and that's one of the reasons I think he punished the solicitors, was that the solicitor had some involvement in that. Now, how do you see the view of the judge there and going forward, suggestions for solicitors? Is it a position that, as solicitors, that where we have a doubt on the caveat, we just basically tell the client there's no caveat, we just don't get involved in it and don't give them any assistance. But then, if the matter comes back to you and the caveat's been lodged by the client, there is a positive obligation on the solicitor to really obviously not issue proceedings or not defend proceedings. How do you see that?
Elizabeth?
In that case, the two caveats were in identical form, and one was filed by the solicitors and the other was filed by the individual, so the court drew a not unreasonable inference that the solicitors had drawn both but refused to file one of them. And that was really where the court distinguished between the difference between doing the document and continuing to defend, and basically had this fallback position where it said, well, look, even if it might have been okay to draw the caveat, you're well into past the grey area by the time you get to the defending it. So there's a grey area between the time that you get your instructions to draw it and that grey area ends at the time you're defending it. I think that probably, I don't think you really should be drawing documents that can't be used. If there's no proper basis they can't be used, I can't see why you would draw it. So I think we're getting pushed out of the door. So that's my quick views. I don't see how you could, but I don't think you're going to get in trouble until you defend it.
Thank you. I see the time, I feel the air conditioning hypothermia, and I hear the jackhammers. I think it's time to go. Thank you very much, Elizabeth and Nick, for their excellent efforts this morning. Seek a round of applause.